And let's stay then with this particular story, and we speak to Professor Andre Thomashausen, who's a Unisa Professor Emeritus of International Law, and lots, of course, to unpack when you look at the President's affidavit. Prof, thank you so much for your time this afternoon. One of the things that the President is arguing in that particular affidavit, he says, and I quote, "I must highlight for the sake of transparency that South Africa has obvious problems with executing a request to arrest and surrender President Putin. Russia made it clear that arresting its sitting president would be a declaration of war, and it will be inconsistent with the constitution to engage in a war with Russia." This, I suppose, as we go into Friday, is likely to be the big argument.
Well, I think it highlights that we have a little bit of an excessive or even ridiculous tendency in South Africa to refer any controversial political matter to a court, as if judges were the incorporation of wisdom of a country. And poor judges, they can apply the law, but they are not mandated, and they were never elected to take big political decisions. And it is a big political decision whether South Africa wants to continue to be a member of the BRICS and to promote the BRICS alliance through the summit in August, which will see a significant enlargement of the BRICS, or whether South Africa wants to maybe join some other countries that are rejecting the BRICS and are sticking to their Western alliance. And it is a big political decision whether we want to offend one of the superpowers in this world, maybe the second or the third most powerful nation, Russia, by sending some little policeman in his uniform to maybe try and arrest him in his hotel or at the door of the embassy. It is actually a little bit humorous. It's like a caricature to see two or three cops very embarrassed, very awkward, trying to arrest that man. And obviously, Putin's security would never allow a South African policeman to come near him. So these are kind of strange meanderings in the judicial system, and I actually feel sorry for the judges that will have to hear this matter on Friday and will then have to come to a conclusion.
And one of the things, as you mentioned there before we even delve into some of the other parts around confidentiality, is around this particular arrest. And in his papers, he says that the National Director of Public Prosecutions is the relevant functionary to whom the warrant is, would be forwarded. But I wonder, who then has the jurisdiction to ensure that he's arrested? Is it the Hawks? Is it the police? Who is it?
Well, for starters, I think the DA's application suffered a bit in its quality by having been entrusted to a law firm that is best known for their excellent work in enforcing lease agreements and property deals. There is a marked ignorance of constitutional law and a marked ignorance of public international law in those papers. Public international law is always a law of consensus. There is no international lawmaker. There's no international parliament. So things happen by agreement of countries. And this is why the statute, the Rome Statute for the International Criminal Court, provides a two-step procedure. First, a warrant of arrest is issued by the pre-trial chamber to signal that a certain person is now being sought. Then it requires in Article 59 that a specific request must be made to a state where that person may or may not be found. We don't know if such a request has been made to South Africa. As long as no request under Article 59 has been made, nobody in South Africa has the authority to do anything or to prepare anything. Once a specific request is made by the ICC to arrest Putin, and that will only happen if the ICC finds out that Putin is indeed on his way to South Africa. Once such a request is made, yes, then a magistrate's court will have to be requested by the NPA to issue a warrant for the arrest of the person sought by the International Criminal Court. But we're not there yet, and this is one of the main objections in the replying affidavit of President Ramaphosa. that this whole matter is premature. The court is being asked to decide things that may or may not happen.
And also, as he raises the fact that under Article 9, they are still then having some negotiations and consultations with the courts, because there is, of course, that particular clause that allows that a country can then, a member state can then engage in some of the consultations in that regard. But, Prof, I wonder, because one of the things that the DA is arguing in its own case is that there hasn't been a clear decision in the public domain about how they're going to be dealing with this matter. Will they arrest? Will they not? But the president in his papers saying that the government knows exactly what to do in this particular regard and they will not be caught off guard. And I'm paraphrasing here, but how much does the government then have in terms of a responsibility to let in South Africans into its confidence, to tell us exactly how do they plan to deal with this?
Well, you mentioned a crucial provision. And it was actually me on this SABC channel that drew the attention to Article 97 for the first time, because even the most senior legal people at DIRCO in charge of these matters had admitted to me that they never read the whole Rome Statute right up to Article 97. Right? Article 97 acknowledges that people have to agree on these matters, and that when a country is prevented by previous international treaty obligations to execute a warrant, then that country must consult with the ICC. And that's very logical. And of course, South Africa is prevented by the Vienna Convention on Diplomatic Relations and ever so many other commitments to arrest a sitting head of state of a country that is not a member to the ICC. It would be different if Russia had signed the Rome Statute, because then by doing so, it would have waived its absolute rights of sovereign immunity for heads of state. Now, Ramaphosa quite rightly reminds the court that not all matters of international and diplomatic relations can be debated in public. This would offend the necessary confidentiality of such consultations and of such relations. They're delicate. And they shouldn't be held in public and through newspaper articles and readers' letters. It won't help. And the main argument, of course, is that South Africa, together with 5 other countries in Africa, is engaged in a mediation process. Both Ukraine and Russia have welcomed the African Peace Initiative. They have asked for it to continue. Even last week, President Ramaphosa spoke at length, over an hour, with President Zelensky, and then afterwards again with President Putin. And now on the 28th, there will be further meetings in St. Petersburg. There is an engagement, and it's ongoing. And how can you mediate if you go and arrest one of the parties to the conflict that you're trying to mediate? This is highly counterproductive, and this is what Ramaphosa has highlighted in his response to the court, that the DA is not pursuing a constructive agenda. It is pursuing rather bad opposition politics, where they're trying to score points in the public eye as a small minority party with way under 20% of the votes in this country. And in the process, they may very well be seriously damaging this ongoing peace initiative.
All right, Prof, I suspect we'll speak again on Friday, just after those arguments, because there's quite a lot to say, especially when we read all the papers in this particular regard. But let me thank you for your time. That was really quite enlightening. That was Professor Andre Thomashausen, Unisa Professor Emeritus of International Law.